Hi, I'm Scott Marcus. I'm an Associate Senior Research Fellow at the CEPS here in Brussels, and I'm also a part-time professor at the Center for Digital Society at the European University Institute in Fiesole, Italy. So our topic for today, our bright idea, is how can we make this avalanche of new digital legislation, how can we make these new laws play together properly? Now let's first talk a little about what level of new legislation we're talking about. I'm a co-author of a data set of all digital legislation at European level. The number of entries that we had for 2012 was 20. The number we have today, 88. So a fourfold increase in just a little over 10 years. That's a big jump. But also the complexity of the recent laws is enormous. In past years we had the European Electronic Communications Code, we had GDPR. More recently we got DMA, we've got DGA, we've got the Data Governance Act, we've got the Data Act, we have the Artificial Intelligence Act. These are large, complicated laws. And what we see is that there's substantial risk of mismatches of problems. We also see in survey results that business is worried, both about the volume of new law and about the risk that they don't play nicely with one another. So that's really what we're looking to address today. Now, there are at least three dimensions of making sure that these things work properly together. One is, how do they play in the member states? Another is, how do they work in the member states in terms of their coordination with the European institutions? But a third, and a really growing problem, is how do we make sure that they operate properly across different thematic areas? These touch so many different things, topics that historically were disconnected from one another, that we thought of quite independently from one another, suddenly have to play nicely together. Think about privacy, competition law, and also consumer protection. Today they're all linked in their implementation, they're linked in court cases, but they were really designed independently of one another. Now, we've had some efforts to address this. The UK was a pioneer. They set up a council where several of their different regulatory authorities would at least talk to each other and try to ensure that there was some consistency. That approach was taken up by the Netherlands. There are also similar things happening in a number of the other member states, but it's not an overarching kind of solution, and in many cases it deals with a limited number of laws. At European level, we have one example that bears mentioning. That's the DMA and its high-level group, where a few regulators come together with the authorities that implement DMA. Good, but again, it deals with one law, basically, trying to make sure that it works correctly with the others. It's not a general solution. And that's really what we're talking about today, is how to make things work better overall. The kind of things that I'm proposing today are, on the one hand, a group similar to the high-level group, similar to what the UK and the Netherlands did, but at European level. The question would also be, given that today each of these laws has its own mechanism for coordination across the member state, couldn't we have a template or two such that they don't have to all be quite as different as they are today? It's hard to fix the existing laws, but at least with new laws we could try to ensure perhaps a bit more consistency in how all of this is done.